Okay, so for those of you who don't already know me, my name's Stu Flashman, and I'm an attorney. I'm in Oakland, California, Bay Area, and I have been an attorney since 1990, which I guess makes it 32 years. And my main area of focus in my practice is environmental law and land use law. And both of those are certainly very relevant to the issues that are before us this morning. Um, and Let me introduce Doug Carstens. Um, I don't know if I see him. Well, I don't see him, but I think he's in here.
I
But
am
there's a
here.
lot of,
Hi, Stuart.
okay, very good. Um, So Doug is also a CEQA practitioner attorney, and he's been practicing. Um, I'm not sure whether it's longer or not quite as long as I have, but we have worked together on a number of cases, and we're both, I think, considered pretty well-established attorneys on CEQA issues. And the topic that he and I would both want to discuss today is um, what's going on in terms of tax on CEQA, which is that CEQA was enacted in 1970. It was actually signed into law by Governor Ronald Reagan, which says something about at that point there was a fair amount of um, people basically supporting stuff on the environment regardless of party lines. And in fact, just about that same time, just slightly before, the Congress enacted the National Environmental Policy Act, which is the law on which CEQA is based. And that law was signed into effect um, by President Richard Nixon. So back then, there was a lot of Republicans who supported environmental protection. And maybe not so much now, and certainly not so much now are Democrats supporting environmental protection. Um, but we've seen, gosh, actually, since I started practicing in 1990 rather, we've been seeing a attempts to weaken CEQA and narrow its scope and exempt more and more types of projects from CEQA. And I think that's what Doug and I both wanted to talk a little bit about this morning is what's going on and and why it's not really appropriate to talk about cutting down on CEQA, particularly if your concern is that we're not building enough housing, because I think both of us feel that CEQA is not an impediment, and there have been a number of studies that show that CEQA doesn't interfere with building housing to any significant extent, and perhaps equally, if not more importantly, CEQA can inform decisions on housing projects and make sure that when you build a housing project, you understand what its environmental impacts are going to be, and if those are bad impacts, you do something about them. And the concern we both share is that if you start making CEQA inapplicable to housing projects, then you're going to get a lot of projects that will create environmental damage, and we'll only find out about it afterwards. Doug, do you want to do a little bit more of introducing yourself?
Well, sure. Thank you, Stuart. I'm just changing my video to a background, and I see a hand up already. We'd be glad to get the questions and answer. Let me just say a thing or two. I mean, we have a practice, a very small law firm in Hermosa Beach, California, in the Los Angeles area, statewide practice, but very similar to Stuart's, very concerned about how environmental protection and review and basically citizen participation in government is being conducted throughout California. CEQA, the California Environmental Quality Act, is its premier law, one that is like a safety net that ties a bunch of other laws together to make sure governments are reviewing proposed projects correctly. And we have seen a lot of attempts to roll back or deregulate, both in terms of full frontal assaults. There was once an initiative to entirely repeal CEQA that didn't get anywhere. There's more commonly what we call attacks or attempts to create death by 1,000 cuts, little nicks here and there, and thousands of them repeated over and over to roll back various provisions of CEQA or weaken it. And every one of those is an attempt to take away power from people like us to participate in government and hand it over to the developers or the insiders in government to basically achieve their self-interest. CEQA has been called a Bill of Rights for an environmental democracy. That was how it was characterized by Byron Shear, who was instrumental in its writing and authorship. There's a lot that has been said about CEQA. We actually, I and a person named Roger Lynn have written an article trying to counter the attacks, which we call the big lie that is told about CEQA, that it slows down or interferes with housing production. These are basically attempts by moneyed interests to basically get barriers out of their way, and they've perceived an attack on CEQA as being one of the things that will make their life easier and more profitable. I want to read what the Attorney General wrote about CEQA in a case called Natural Resources Defense Council versus the City of Los Angeles. This was about in 2001, and it captures, I think, some of the majesty of CEQA and the process. And it was written, the CEQA process is intended to be a careful examination, fully open to the public, of the environmental consequences of a given project, covering the entire project from start to finish. This examination is intended to provide the fullest information reasonably available upon which decision makers and the public they serve can rely in determining whether or not to start a project at all, not merely to decide whether to finish it. An EIR, or an environmental impact report, is intended to furnish both a roadmap and an environmental price tag for a project so that the decision makers and the public both know before a journey starts or begins just where the journey will lead and how much they and the environment will have to give up in order to take that journey. As our Supreme Court in a case called Bozung said, the purpose of CEQA is not to generate paper, but to compel government at all levels to make decisions with environmental consequences in mind. I find that as one of the best encapsulations of what the CEQA process does and what it's supposed to do. And I think that also explains why it's come under a lot of attack, because it's incorporated in a lot of processes. And when people fail to plan well enough or ahead of time, a lot of times the blame falls on CEQA for things happening surprisingly or wrongly. CEQA is like a stitch in time that saves 9. If you plan ahead well enough, then you don't, get suddenly surprised by your project being stopped or avoided. But if you fail to plan well enough, then you suddenly blame the government or CEQA on what turns out to be your own fault for not having brought your project along in the right way. So I'll end up right there and maybe turn back over to Stu and others to either take wherever questions and answers or further discussion. But what do you think, Stuart?
Yeah, I just add a couple of things. There are a couple of things that have been called where CEQA has been called. My favorite is to say that CEQA is the look before you leap statute. That you have to look at what the environmental consequences are going to be before you start making big decisions, and you don't end up later on saying, "Oh gosh, I wish we hadn't done that." And the other thing that it's been called is an environmental alarm bell. And essentially, its intention is to make the public aware and to involve the public in discussing a project potential environmental impacts. And then if the government goes ahead and decides it goes ahead and approves that project in spite of those impacts, then they can be held accountable. Because the voters can say, you knew that project was going to cause damage to the environment. You went ahead and approved it. That's not okay. We're not going to reelect you. And that's the intent of CEQA, is really not so much that in itself will stop project, but it holds that sword over decision makers to say, you screw up here and you're going to lose your office.
Stuart, I think that's so important because a lot of times, a lot of people use this perception that CEQA stops projects, or, CEQA cannot, by law, cannot stop projects. It basically requires reviewing projects carefully, but then there's these things called statements of overriding considerations that allow agencies and developers to go ahead and approve a project despite its impacts. So it is very much a look before you leap type statute, but it's not going to stop people from leaping unless a court issues an order. So that is a highly important point, Stuart. And I do like the point about accountability, because it requires and imposes responsibility on the elected officials who make whatever decision, that they have to fess up to it, they have to own it, and the public and the electorate can hold them accountable for it.
Yeah, I'm going to get to the questions, but I just want to mention one thing, which has been one of the recent cases that people have pointed to, particularly a lot of politicians have pointed to, and saying that's why we have to reform. That's the term they use. We have to reform CEQA, and that's the case involving University of California at Berkeley, which those of you who live in the Bay Area know that University of California at Berkeley is a large university, and it keeps expanding and expanding. And one of the things they were supposed to be doing when they did these major expansions is ask about what are the effects of that going to be. And a lot of times they have not done an adequate job of discussing that. And in particular, in this case, they were basically proposing to build some student housing, student faculty housing, and it was mostly going to be for graduate students. And as those of you who live in the Bay Area probably know, that UC Berkeley has nowhere near the dorm space that's needed to house all its students. So a lot of those students end up living off campus in housing within the community. And one of the results of that is if you're housing students there, you're not housing non-students there. And it's put extra pressure on the Berkeley housing market and caused extra increases in the prices, particularly in the rental market in Berkeley. So that was the impetus behind the lawsuit, was to say, hold on, Berkeley, you're keeping on expanding and adding more students, and you're not addressing the effects that all of those extra students are going to have on the surrounding community and our resources. And the judge very properly said, university, you can't keep going ahead doing this. You have to stop and examine this before you continue to expand. And the legislature's response, particularly some of the people who are looking to hamstring CEQA, jumped on that and says, all right, we're going to exempt the housing at UC from environmental review. They didn't put any cap on. They didn't say, well, we're going to do it for the next 3 years. They didn't do it by saying, well, we're going to say you have to, if you have an emergency need for putting more housing in, you can do it until you meet that emergency, and then you have to stop and look at it. They just said, nope, we're going to drop it out altogether. And so it was an excuse, and it frankly is a damaging situation where the legislature is stepping in. Unfortunately, the legislature is about the only agency that doesn't have to do CEQA. When the legislature passes laws, they don't have to think about what the environmental effects of those laws are. And I suppose that's a weakness of CEQA, but there it is. So that's, anyways, I just wanted to point out that particular impetus for people who are trying to tie down and reduce CEQA's impact. Rick, do you want to?
Yeah, before we get to the hands that are up, I'd like to just sort of ask a question of you guys, and that's sort of what can we do to protect CEQA, especially when it's being attacked by this 1,000 cuts sort of approach. Certainly one of the things we can do is what we're doing today, educating our members on CEQA, but we can oppose bills that are 1,000 cut bills as we see them. But what can people in general do to protect CEQA?
Doug, you want to jump in there?
I'd love to. I was waiting, Stuart, and thank you, Rick, and thank you, for inviting us this morning and the time. That is so important because every one of us has a different skill or level, whether it's writing to our elected officials, which is pretty high on the list. Every elected official has a role in understanding the importance of CEQA. A lot of them, it doesn't necessarily come up on their radar because at the state level, they're not dealing with the municipal or county level decisions in land use, but they're making decisions that empower people or take power away. So educating elected officials is very highly important. There's an organized and orchestrated campaign against CEQA funded by developers and banks and real estate interests. So a lot of times you'll see op-eds, letters to the editors. Basically, there's a misinformation campaign. So if you see that in your local newspapers or anywhere, I would suggest strongly a counter letter, or it reminds me of Winston Churchill. You fight them on the beaches and in the corners and the hedges. Everywhere you see an attack on CEQA, it's got to be countered. And Stuart, strong stalwart for CEQA. I am. A lot of people are, but we can't see every attack that occurs. But every attack should be answered, or every attack should be countered some way or other. And this is a start. I put a link to the article I wrote in the chat. I put in the statement in the chat. Thank you for people asking for those things. So we are so glad people are interested in asking questions, and anything we can help to provide the talking points or the counters to what you see, very glad to do that. And thank you for even asking and trying to, because CEQA is for all of us. So thank you.
Thank you, Doug. First question I see is John Welborne.
Thank you very much, Rick. John Welborne here in Los Angeles, longtime real estate lawyer, fan of Doug, former client.
John, good to see you.
Fight. And thank you both for being here. Could you please address one of the arguments that is being brought up against CEQA, that it is being misused by construction unions, hotel unions, and others as a negotiating tool for their own purposes, using it as a delay tactic? Thank you.
Mm-hmm. And thank you for that question. That's one of the stronger attacks, I think. It's not just unions, but we also see attacks on the basis of competitors, business competitors, allegedly misusing it. I put misuse in air quotes. You also hear the word abuse or whatever else. But I think any attempt to enforce the laws, we have to remember who's breaking the laws here. The developers are breaking state law when they don't comply with CEQA. So if it's an environmental group suing to enforce CEQA, or an individual citizen, or a union, or a business, I say enforcement is a good thing. And the fact that unions will file a lawsuit to enforce CEQA and then drop out of it when they get a project labor agreement, I wish they would keep it up. I wish they wouldn't drop out when they get an agreement, but at least they brought the lawsuit in the first place. Because again, the people who are breaking the laws are the ones who are not complying with CEQA.
Right, but what about the argument you can bring a lawsuit and it takes a long time for somebody to make a decision that it was specious in the first place, in which case you have your bargaining power for the cost of delay?
I recognize that, and there are mechanisms in the court to actually get it disposed early. CEQA is on very accelerated timeframes. They move quicker than almost any other civil litigation. It's possible to do summary adjudication. And in terms of actually stopping a project, no project will be stopped unless an independent judge, a man or a woman in the black robe, will actually issue an order to stop a project. So developers can proceed at their own risk, even while court proceedings are pending. And I also recognize the transaction costs of having to go out and hire a lawyer, but people usually are not suing unless there is a basis to it. And if there's no basis to it, then they can be responsible for frivolous lawsuits and penalties of $10,000 or more. And to my knowledge, even though that exists, maybe once, but no more than once, I've ever heard of anybody getting frivolous lawsuit damages against somebody filing a CEQA lawsuit.
Yeah, I think it's important to note that while anybody can file a lawsuit, you need to have an actual cause of action that has some reality to it to get anywhere in the courts. And essentially, there are, one of the things about CEQA is, it's an unfortunate fact, is that particularly for large projects, you end up with these professional consulting firms being brought in to prepare the impact reports, environmental impact reports. And yeah, they're huge. They're these huge volumes. And the sad thing about it is CEQA was intended to have these environmental reports be readily understandable to the general public. And you look at these huge tomes, and you look at all of the use of acronyms and all of the use of technicalities and huge reams of raw data that get attached to these reports, and saying, well, here, this shows this has no air quality impacts. And what you see is literally hundreds and hundreds of pages of charts and graphs and tables. And how is anyone supposed to understand that enough to be able to look at it and say, yes, this is, or no, this is not going to cause air quality impacts? The fact of the matter is, you need to get a professional consultant even to understand the reports that are being put out, and yet these are supposed to be for the general public. It's a real problem. But the consultants are partly to blame, and the public agencies that hire those consultants are to blame, because they're just sort of saying, oh, just go ahead and do something. And they're not really paying attention to saying, look, we want this done right. I knew there was this one CEQA consultant back maybe 10, 15 years ago, and her firm was known for doing environmental reports that were bulletproof. That if they wrote the report and they published it, you don't bother trying to attack it. It's going to stand up in court. It's going to be satisfactory, and they're simply they spoke the truth, and that's what CEQA is supposed to be about. And unfortunately, a lot of times, what CEQA seems to be about is people just sort of, burying it and what do they call it, piled higher and deeper.
And,
That's what you involve PhDs in.
Stuart, can I give just a couple other facts and then get to the other questions? Because this is such an important question from John about the opposition, and I know it's on a lot of people's minds. A couple of the facts I usually also give are CEQA lawsuits are only filed in about 3 out of 1,000 cases, so that's 0.3%. It's a very small volume. Most CEQA review is done on the basis of a negative declaration or exemption from CEQA. 3 to 5% are EIRs that are the full document. And so it's anecdotes that get, blown out of proportion, like the Berkeley thing. And in those terms, I also point out that any law can be abused, again, in air quotes, like the Americans with Disability Act or the civil rights laws. These are very important laws that just because there is some allegation of abuse, the whole law might, potentially come under attack. So I've never seen a developer who has not thought a case against him or her was frivolous. Basically, that's just their claim for any lawsuit that stops them from doing what they want to do. But there's other questions.
Before we move on to other questions, I'd like to ask maybe, one of the, I forget the bill number right now, I'll look it up, but one of the bills moving through the legislature this year requires, maybe Stu can comment on this, requires to put up a $500,000 bond when you file your CEQA lawsuut. And that seems to me to would have a huge chilling effect on small organizations and nonprofits and individuals. So that one seems particularly dangerous to me. Do you want to comment on that, Stu?
Yeah, it is a very disturbing piece of legislation or a proposal. One of the rules about laws in the courts is there's a right to access to the courts. Citizens are supposed to be able to bring cases in court because that's part of what due process is about. is if you can't, under the Fifth Amendment, if you can't challenge something that's being done because it's affecting your life, liberty, or property, then you're violating the Constitution. And a lot of times when people are suing under CEQA, they are claiming this is going to cause tremendous damage to the environment, and that's going to affect all of us. They're in the federal courts, the Ninth Circuit, which is the circuit of the federal courts that covers all of the most of the Western U.S., including California. There's a rule that basically says if you're doing a lawsuit in the public interest, you cannot be required to file a bond, to place a bond before you can move forward. And that even applies when you're seeking an injunction, which is to actually stop a project, not just to file a lawsuit, but to actually stop the project. And what they're saying is if that injunction is being sought in the public interest, no bond. The state of California has 3 times attempted, the courts of appeal have attempted to apply that same rule. And each time the California Supreme Court has depublished the case that would have applied that rule. So we're left in a nebulous zone where we don't know from one day to the next what's going to happen in terms of people requiring bonds. But in general, most courts have been pretty reluctant to lock out, as someone had said, to lock the courthouse door by requiring bonds when you're doing something in the public interest. This case, this law would be flipping the thing around, as it were, turning it upside down, because normally the onus is on the person who's seeking to get a bond required to justify why a bond is needed. This would flip it around and say, no, you're always going to have to have a bond unless the court decides it would be counter to the interest of justice. Well, that leaves it to a judge on a case-by-case basis to say, well, let's see, you're supposed to have a bond, $500,000 bond minimum, $500,000. That's a lot of money. And if you're going to argue against it, you have to convince me that this would be an abuse of justice to require a bond, and that's putting a steep burden on the plaintiffs there, and that's just to file a lawsuit. That's not even to get an injunction. That's not to file an appeal. That's just to file the lawsuit in the first place. So it's a terrible law, and I'm hoping it will be rejected.
Thank you,